Morning, everyone. Welcome to the Supreme Court's May administrative hearing. If you could mute yourselves until it's time to speak, that would be helpful. Thank you. And if you have not renamed yourself, please do that as well, so we know who everybody is. We have a lot of speakers on a number of items today, and we're grateful for your contributions. We'll start with item number 1, which is an amendment of Michigan Court Rule 1.109 that establishes a process for authorizing individuals who have a party's consent to have access to that party's date of birth for purposes of verifying identity. The first speaker is Richard Varn. Mr. Varn, please go ahead.
Thank you. We've submitted written testimony, so I'll just do a quick summary of our testimony here in the 3 minutes that I have. Thank you for letting us do this. I've been involved with identity theft, identity security, and public records issues for about 40 years. And I want to mention that the most important thing is that protecting of birth records, maybe back in the 80s, would be something that was relevant to identity security and identity theft. It is no longer relevant. I've been working on this issue for a long time, and we watched how the cyber thieves have evolved their way of being able to compromise our security and integrity and our money and our personal privacy. And this is not the way they do it anymore. It has become a vast, very complex, well-supported industry that does not rely on public records in any way, shape, or form to perpetuate these kind of crimes and invasions of our privacy. So I believe the first premise of your rule that somehow hiding birth date is a good idea is the one emphasis point I want to say. It is not a good idea. It is used for many viable purposes, and it is not a protectable secret. It is not a secret for most people, and it cannot be kept as a secret. So the whole process that we've now been engaged with to create the identity protection around what you're doing, and the idea of having the background check exemption, we applaud that. We thank you for doing that in the rule, but we think you need to go further to create a vendor solution. If you don't want to make the record public, we think you need a vendor solution that will help the uses of this record, which are critical to securely identify someone, to continue, which are things around law enforcement and other ways that this record is used to verify a person's identity in a number of lawful uses that are dependent on these records. You know, Minnesota and other states, we pointed out, have done this, and they require certain things of those vendors to get access to their record. We encourage you to look at that opportunity if you don't want to just go back and make the records public, and I don't think you do. But we think these vendor approval processes can be done efficiently, and it will protect the data, and it will protect the uses of the data. And you know, as the CIO for the state of Iowa, I was the CIO for the 7th largest U.S. city. I've been managing public records for a long time doing this issue. I guarantee you that this process can be done very efficiently, very effectively using good technology. We encourage you to look at the technology solution and the opportunity to let these vendors continue to get these records and use them for things that I think you as judges and others use every day and may not be aware of it. For security, for auto recalls, for a variety of things that these records are used for. So I thank you for the time for letting us give this testimony today. We presented a white paper and have other information on how identity theft occurs, how these records are used, and any other materials that you would think would be helpful. We'd be glad to provide those as backup and additional information. Happy to answer any questions, and otherwise appreciate your time. Thank you.
Thank you, Mr. Varn, and thank you for the written submission as well. We appreciate the input. It's helpful. Next is Mike Carone. Mr. Carone.
Good morning. My name is Mike Carone with the Consumer Data Industry Association, CDA for short. I'd like to thank the Supreme Court Administrative Office for allowing me to speak today on behalf of Amendment of MCR 1.109. At the Consumer Data Industry Association, we represent consumer reporting agencies across the country, and we appreciate the Supreme Court Administrative's Office allowing us to work with them over the last several months on implementation of a registration system for our members to continue to access date of birth information in court records. We also appreciate the ongoing work with some issues in implementation across the hundreds of courts you have up there in Michigan. And we also do appreciate the continuing conversation on some of the other uses that we've outlined in our comments on other uses for these records beyond Fair Credit Reporting Act usages. I wanted to keep everything brief today, and please feel free to reach out if there's any questions or ask any questions today if you have the time. Once again, Mike from the Consumer Data Industry Association. Appreciate the opportunity to offer comments today.
Thank you very much, Mr. Caron. We appreciate it. Next is Jason Mcneil. You're muted, Mr. McNeil.
Thank you. I had to find that button there. Hi, my name is Jason McNeil. My wife and I own a business called Mcgill Group LLC. We do wholesale criminal background searches throughout the state of Michigan. I just wanted to give you my perspective of what we're seeing with the implementation of the rule. We do about 2,400 names a day in the state. The state has about a 12% hit ratio that we have found. So we have about 290 names per day that come through us that we need to have a DOB verification made for. Our typical search criteria is we look for a 10-year misdemeanors and unlimited felony convictions. That's essentially what we look for, and 99% of the searches that we do are for pre-employment screening. With the new rule and that we had some hurdles to go through as far as getting the DOB information that we need. But I believe that the way that the rule and everything that it's been rolled out on my end, the communication that I've had with Mr. Gamby, with the regional admins, the magistrates, the court clerks, everybody is trying to move into the right direction. And I think that the communication has been very good going down. Some things get missed here and there. The implementation of it with the local administrative orders are causing some concern with us being able to get the information that's correct. What we're finding having to do DOB verifications, that if you have a common name in a county where there is someone else that has, you could be squeaky clean, but if you have a record in that, someone else has a record in that county with a common name, you could miss out an opportunity for employment because it could take upwards of 10 days for people to get these date of birth verifications back up. This is in particular the larger urban areas where there are public access terminals, and those dates have been removed. So now that some of these courts are limiting the number of verifications they'll do in a day. We may find that there are 50 people that need to have DOB verifications in one particular court, and if the court is limited to doing only 10 because they don't have the ability to do so, it puts a great bottleneck and creates an opportunity for somebody to just miss their job. We're seeing that in some of the other courts where DOBs were available online for us before, but now we have to contact the court. It adds a little bit of time for it, but it's possibly a lost opportunity. My short-term solution for that would be if we were going to be doing searches with these online websites with the state of Michigan, that a full date of birth is being required in order to actually create that search, to put something through so that we would know if there was a result tied to that or not. With the DOB, it could still be redacted if you need it on the ROA, but if we had to search with the DOB, it would help. Another solution would be through tech, where whether there was some sort of volume-based subscription service where those of us in the business could get the information that we need for, say, 30 days or whatever, and then have it come back. We are fully insured. The accuracy of the information is paramount for us. So that's my time. So anyhow.
Thank you, Mr. McNeil. Thank you very much for your help with this issue. We appreciate it. Next is Brent Schmoyer. Mr. Schmoyer.
Yes, Madam Chief Justice, members of the court, thank you for this opportunity to testify today. My name is Brent Schmoyer, and I'm Director of State Government Relations for the Professional Background Screening Association, or PBSA. We represent over 650 member companies in the background screening profession, including in Michigan and across the nation, and our mission is to advance excellence in the screening profession. The background reports prepared by PBSA background screening members are used by employers, volunteer organizations, and housing providers every day to help make communities safe for all to use, work, or reside in them. We are all consumer reporting agencies and operate in a highly regulated environment. CRAs are subject to strict regulations under the FCRA, as well as several other federal and state laws relating to background screening, protection of personal identifiable information, information security, data transfer, and more. I'd really like to focus on one of the key mandates in the federal legislation, that CRAs must achieve maximum possible accuracy, which includes reporting criminal records on a background check only if they are about the person the check is about. That's why Amendment MCR 1.109 is so vital to our industry to ensure that we can continue to provide timely and accurate background checks to Michigan employers. Background screeners use date of birth and court records to verify criminal defendants and ensure that record is actually about the applicant themselves, because it's quite possible the applicant has a similar name to someone else, as Mr. Mcneil stated. Screeners can further identify the identity with the clerk using social security number or driver's license if necessary, both of those provided by the applicant. Without confirming a match or identifier beyond name, background screeners are unable to report criminal records. And because federal regulators are now requiring even more accuracy in their reporting than just a match on a name. So we appreciate the cooperation and collaboration of SCAO. This amendment is going to allow our industry to continue to supply employers, nonprofit associations, and groups that work with the most vulnerable populations with reliable and accurate background checks in Michigan, while allowing the SCAO to take steps they believe necessary to protect the privacy of Michiganders. This amendment will allow us to function efficiently, confirm whether date of birth and protected identifiers match those of the background screener that were provided by the applicant. This rule change at its core is about public safety, and the SCAO has seen that through our negotiations and discussions that it is about public safety, and we are very appreciative they both have taken the time to understand the issue and to find a way for our membership to continue to provide our vital service to the public. We just ask that you keep Michigan communities safe by granting final approval to this important change and ensuring access to complete and accurate background checks. Thank you very much for your time.
Thank you very much. And I want to apologize to my colleagues for not stopping and pausing to see if people had questions for each of the speakers. So I will do that now for all four speakers on item number 1. If there are any questions for any of the 4 speakers, go for it. If not, I promise to do better when we start the next item. Okay, seeing no questions, thank you all for your comments. Very helpful. Item number 2 is a proposed amendment to Michigan Court Rule 7.212 that would require appellate briefs to be formatted for optimized reading on electronic displays. The first endorsed speaker is Gerald Posner. Mr. Posner. Mr. Posner, I saw here a moment ago. Are you still here?
Unmute would help.
Oh, yeah.
Thank you, Your Honor. As many of you know, I've been doing both trial work and appellate work for almost 48 years. I've been on the counsel of the appellate practice section for almost 19. I was involved in the e-briefing pilot program. But as far as this proposed rule is concerned, I am the voice of strong dissent. I wrote a lengthy comment in January to the court, along with the proposed redraft of your rule to comport with my belief that if we're going to change anything, we change it to an either-or approach, either 50 pages or 16,000 words. Only if a brief hits around that 50-page mark do word limits become relevant at all. I applaud the efforts of those on the committee that want a chance to have shorter line lengths to go on an iPad, larger fonts, different fonts, charts, so forth, to have flexibility in formatting. But the truth of the matter is 98% of the lawyers in this state have never dealt with word limits and don't want to deal with word limits. Unless you have done a federal appeal, there's no reason to deal with word limits. It has both to do with technological expertise, ease of use, planning a brief for substantive issues, and access to justice. What we have in this case, people don't deal with it. I've polled attorneys in all kinds of fields and their staff. They don't want to. There's no reason to have to go to word. If somebody gives you a 30-page brief, why are they screwing around with a word limit? It's irrelevant. And it goes to the planning stage of a brief. I know when I'm trying to figure out on an appeal what substantive issues can be raised. I know in the trial court, we've had certain motions, we've had things, these take so many pages. We've had jury instructions, they're pages, or certain pages of transcripts that go in. I can judge it. I can't judge it by word limits. And it also has to do with access to justice. If attorneys find this more difficult or time consuming, which they will, they either are not going to take an appeal or they're going to have to charge the client more. And the clients we have can't pay for those kinds of things. I would urge this court not to put an artificial impediment to briefing for the vast majority of attorneys in the vast majority of cases where we don't go up to 50 pages, or in the alternative to extend the e-briefing pilot program. I understand only about 7% of cases have had at least one brief in that format, which means less than 5% of the briefs total, which means neither the court nor the attorneys have had a good opportunity to go through that alternate formatting. And we did try in that pilot program to tone down some of the techies to make sure people deal in paper, judges deal in paper. Let's make it usable for everybody. And I think this rule has to be usable for everybody, not
Thank
just
you.
a select few.
Thank you, Mr. Posner. Are there any questions for Mr. Posner? Thank you so much. Thanks for your comments. Jason Long.
Good morning, Chief Justice McCormick and your honors. May it please the court, my name is Jason Long. I'm an attorney at Williams, Ratner and Plunkett in Birmingham, and I just want to speak up in favor of at least one portion of the court's proposed amendment, which is moving to a word limit rather than a page limit. In my practice, I handle a lot of issues involving real estate, and very often the most effective way for me to communicate something to a court is to include a map or a drawing or some sort of diagram of the property that is in dispute. And I do that, and it uses up a lot of my pages and limits my ability to present other arguments. Moving to a word count would help with that tremendously for me, and I think therefore for the judges that are reviewing my cases. I won't have to give up argument or squeeze little teeny photos in a brief to try to not crash the page limit. That's the extent of my comments. I really think that the word count is a good idea, and I urge the court to adopt it. Thank you.
Thank you very much.
Doesn't a picture count for 1,000 words in our new rule?
I think that was more of a comment than a question. You
Yeah, seeing that you use less than your allotted time.
Depends on the picture.
Write a 50-page brief.
It was mostly rhetorical.
Thank you very much for your comments. Scott Bassett.
Good morning. Thank you for the opportunity to appear. I've been doing appellate work in Michigan for a little over 40 years. In that time, we've had relatively few changes in the briefing formatting. We've had some appendix court rule changes, but we haven't really kept up with the changes in technology that we've seen over the last 4 decades. And as you know, the appellate practice section is supportive of the proposed amendment to 7.212 and going to a word limit as opposed to a page limit. However, I'm not speaking for the appellate practice section today. I was actually chair of the section's e-briefing committee for the 2 years it took to put together what became the pilot program in Administrative Order 2019-6. And what I'm going to suggest is an alternative to adopting the proposals before the court. And that alternative is to continue the pilot program. As Jerry Posner suggested, there's been relatively few pilot program briefs submitted to the court. The pilot program took effect just before the pandemic hit. It expired after 2 years. Although the court is still accepting pilot program formatted briefs, and we do appreciate that. We do think that I do think that there is some merit to continuing the pilot program. Let's see what happens for another year or 2 years. There's a lot of inertia in law offices when it comes to formatting briefs. During the pandemic was an especially hard time to be able to retool ourselves and our support staff to file those briefs, although some have been successful in doing it. But I think now that we're hopefully coming out of the pandemic and we're having greater ability to communicate with our support staff, that possibly this is the time to extend the pilot program and see what happens. I would note that the proposal before the court today leaves out one important element of the pilot program that I would like to see continue, and that's on the line spacing. The proposal would continue the restriction to double spacing. We did a lot of research in the e-briefing committee and determined that most people find double spacing to be less readable than someplace between, roughly single spacing and 1 3/4 spacing. And the pilot program gave attorneys the ability to deal with that, whereas the proposal before the court now does not. So I think there's some merit to saying, hold on just a minute. We don't need to rush into this. Let's give the pilot program another shot.
Thank you, Mr. Bassett. Any questions for Mr. Bassett?
I do. Mr. Bassett, you mentioned inertia and the low percentage of participants in the pilot program, and suggest that we keep it going for a little while longer to hopefully get more participants. Do you think that the low percentage is a result of the fact that it is just a voluntary pilot program, as opposed to, actually after 2 years issuing the rule, that there's that sort of inertia that people aren't going to do it unless that is what's required of them?
I suppose there is some of that. But I also think, from working on the e-briefing committee, that a great many appellate attorneys are highly motivated to give the judges and staff, because you're the consumers of our product, a product that's more easily readable. I do know that, one of my appellate colleagues, I think she's on the list today to speak, Lisa Speaker, her law firm has adopted the pilot program as their standard briefing. And I think as time, and that was just recent, and I think as time goes on, more and more appellate attorneys will do that, even if it's not mandatory.
Okay, thank you.
Thank you, Mr. Bassett. Next is Lisa Speaker.
Good morning, and I am Lisa Speaker, speaking on behalf of the Speaker Law Firm. Scott is correct that our firm recently implemented the pilot project in February, and I think part of the delay was due to the pandemic, and everybody was moved to the house to work out of their house for a long time, and it was really disruptive, and we weren't in a position to take on a new project. But now that we've done it, we've completely went, the day we decided to do it, everybody did it all the time. And a couple of features about the pilot program that we really do hope is extended if the court is going to adopt the court rule before it today. One, it makes the briefs more readable, and we do want to advocate in a way that's going to make it easier for the judges to read our briefs. Two, it gives us another tool to be effective appellate advocates. Like Mr. Long stated, I love putting charts in briefs to the extent that it's helpful to the courts, and that does take up a lot of room. And I feel like you can be a better advocate by having the space available for pictures or charts or what have you. And I also have talked to my staff who actually do the job of formatting the briefs and getting them out the door for us. And they have told me unequivocally that using the pilot project has saved them time in getting the briefs finalized and out the door. And they are very much opposed to the concept of having to go back to the old way. I mean, they're not so much opposed to the word count, but having to go back to the old formatting with the word counts is going to take up a lot more time, which we recently discovered. We had an attorney on our team who's been out for a while. And when she came back, we forgot to tell her that we had made the switch to the pilot project. And so she did the brief in the old format, and it took the staff a lot longer to get it ready to go out the door and be filed. I also wanted to mention one more thing about the word count and the motion. I'm really happy that there's a motion option that can be filed with the brief. But for family law cases, I think that the standard of having extraordinary circumstances, unless the court thinks that any circumstances is extraordinary family law case, very rarely, we've only done a motion one time, and it was this week on a case where we had to get more words, 3,000 more words actually. But because we don't have a lot of extensions available to us, we have to have good cause to get an extension. We have very extensive records with lots of days of trial. Sometimes it's really difficult to get a brief into 16,000 words. And like I said, since February, we've only had to do that motion one time. So I don't think it's going to be a regular occurrence, but I think there maybe needs to be a little bit more flexibility in the language of the rule for like custody cases, termination cases, and even divorce trials.
Thank you, Ms. Speaker. Any questions for Ms. Speaker? All right, thank you all. Moving on to item number 4, which considers proposed amendments to Michigan Court Rules 6.302 and 6.310 that would require a court to specify the estimated sentencing guideline range as part of a preliminary evaluation of a sentence, and clarify that a defendant may withdraw a plea when the actual guidelines range is different than initially estimated. We have one speaker endorsed, Jacqueline McCann.
Morning, Your Honors. Jacqueline McCann on behalf of SATO. We are on the fence on this one, and we do support greater transparency, and we know that people are most concerned often with how much time they're going to be serving. So those are important aspects of the proposed rule. But we do share the concerns expressed in the Michigan Judges Association's letter, and we are asking the court to consider this further and perhaps seek input from some trial level defender offices and prosecutors' offices to get a better handle on what it would look like on the ground. And we appreciate the court's consideration.
Thank you, Ms. McCann. Any questions for Ms. McCann? Okay, item number 5 is considering a proposed amendment to Michigan Rule of Professional Conduct 1.8 that would clarify that the inclusion of an arbitration clause in an attorney-client agreement is prohibited unless the client is independently represented. In reviewing the provision, the first endorsed speaker is Ann Pfeiffer. Ms. Pfeiffer.
Ackley Pfeiffer.
Yes.
Yeah. Thank you, Your Honor. Good morning to all of you justices. Thank you for the opportunity to speak. As I explained in my written comments, I'm concerned that the proposed rule is going to put a burden on religious lawyer-client relationships. Major religions discourage litigation among their adherents. They're supposed to resolve their disputes in-house, if you will. Religious clients often seek an attorney who is like-minded, and they expect that any dispute with that attorney would also be resolved in-house. And so a pre-dispute arbitration clause takes care of that, and it ensures that both the lawyer and the client, if they run into a conflict, they're going to have it resolved in accordance with their beliefs, maybe even with their spiritual leaders. The proposed rule makes it harder for a religious client to do what they already want to do, which is to ensure that the dispute with their attorney will be resolved in accordance with their religious beliefs. And so for that reason, I support the proposal that has been approved by the ADR section, which would make it optional for a client to seek the advice of an independent attorney. I do appreciate this proposal from the Supreme Court. I think it has raised all of our conscience to pay more attention to informed consent. And I certainly appreciate the opportunity to do that with my clients. I don't represent clients, but I'm a mediator. And so I use a meet-arb clause in my agreements with clients. And this is reminding me that I need to make sure that people understand what they're signing up for when they agree to the arbitration clause. But in my experience, when I have explained it, people welcome it. They appreciate that if there's any concerns, it's not going to go to court. They can go right into a religious arbitration process. So I thank you for bringing this to our attention. And I think if we just tweak the rule so that it's optional, I think I can endorse it along with the section. Thank you.
Thank you very much for your comments. Any questions? All right, the next speaker is Erin Arshard.
Good morning, and thank you for allowing me to speak today in my role as chair of the State Bar of Michigan's ADR section. What we want to emphasize is the importance of informed consent. So we believe that arbitration is one of any number of useful processes that can be used to resolve disputes between attorneys and clients. And we'd like to see any rule regarding arbitration's use in attorney-client agreements focus on the client's informed consent to the use of arbitration to resolve issues. So this can include understanding the benefits of arbitration as well as its potential disadvantages. We feel that attorneys are called on repeatedly to explain legal matters to clients, and this extends to explaining to clients the legal effect of provisions within their own agreements, just as Ann was referencing a minute ago. The State Bar of Michigan's Board of Commissioners voted against requiring outside counsel for the inclusion of arbitration provisions, and they authorized us to submit our written comments to the court, which we've done already. In those comments, we stated that we believe that a rule should require that the client be properly informed of the advantages and disadvantages of arbitration, and should have the opportunity to consult independent counsel if they would like, but it shouldn't mandate that the client actually consult independent counsel. We also suggested that the new rule, if it is adopted, be moved so that it's clearer that the use of arbitration is not actually a prohibited transaction, but merely one that requires the informed consent of clients. And after we submitted our comments to the court a few weeks ago, members of the section have continued to work with other stakeholders in the state on this issue and talking about this question of how best to achieve informed consent. And I think that's an ongoing conversation. I would like to publicly credit our section member, Mike Lieb, for his tremendous work in spearheading this effort to connect with other stakeholders and have these conversations. So working with, among others, Ken Mcgill, who I know is here today as well, we developed consensus language both for a new proposed rule that focuses on informed consent and also on developing some proposed comments that would provide guidance on what constitutes informed consent. And so our sections council approved that language last Friday, and we've submitted that proposed consensus language to the court. And I believe that Ken will likely be speaking more to this additional proposed language. So I'm happy to let him do that, given I have 10 seconds left.
Thank you very much. Any questions? Okay, thank you. Next is Ken Mcgill. You are muted, Ken.
Of course. Sorry about that. Very grateful to the court for taking up this issue. I happened to have been chair of the Professional Ethics Committee at the time R23 was issued, and am intimately familiar with the history. We felt that there was a need to protect vulnerable clients for individuals where if there's a mandatory arbitration clause in a fee agreement, it's essentially shutting the door because they won't be able to afford arbitration, and you end up giving a free pass to lawyers to engage in conduct that would otherwise take them to court. On the other hand, we also found that, consistent with what Aaron's has spoken about, that there are any number of cases where the client as well as the lawyer has a legitimate interest in being able to pursue arbitration without an undue burden. And so what we wanted to do was balance the need to protect vulnerable clients with the need not to create an excessive impediment for parties in cases where it's in everybody's interest. And that was the framework on which R23 was based. As Aaron mentioned, Mike Lieb and I and others have been in touch since the comments came out. We've developed some tweaks to the proposed language that we think takes care of this balance. I also think that it's important for the court to act for another reason, and that is because there's been some significant tension between the position of the ethics community and the Court of Appeals in various cases. And it's whatever the court does will hopefully be helpful in resolving that. We also believe that it is important to understand that there is a need. In my practice, I see fee agreements all the time, and I know at least one of the speakers is going to question whether there's a need here. The incidence of mandatory arbitration clauses in cases involving vulnerable clients, I think, has gone up enormously in the last decade, and calls for protection from the court. Last point, I think trying to put this in 1.8H is shoehorning it where it doesn't belong. It would be very easy for the court to create a separate sub-rule. 1.8K would be the next one. It strikes me that makes good sense, strikes us as this would make good sense. It flags it, it keeps it as a standalone where it belongs. And I guess the really the last point, we wanted to work on comment language. It's a little bit more detailed than normal, but to provide the kind of guidance, again, that Aaron talked about, that we think would be very helpful for practitioners to implement this in a way that serves everybody's interests. Thank you very much.
Thank you, Mr. Mcgill. Any questions? Next is Kimberly Uhuru.
Thank you and good morning, Chief Justice and Justices of the Court. I represent the Attorney Grievance Commission.
The commission supports the proposed amendment to 1.8 because we believe it provides client protection at a critical stage in the attorney-client relationship. And that is when the retention is taking place. I'd first like to address the counter proposal submitted by the ADR section of the State Bar. The commission believes that this is a potentially useful approach in providing guidance to attorneys seeking to advise clients regarding arbitration, but believes that it is insufficient, primarily in the way the suggested amendment is structured. Under the ADR version, the factors relating to arbitration are included in the comment section of the rule rather than the body of the rule. Of course, the comments are merely guidance. They are not authoritative and they're not binding on the lawyer. This means that there's no actual requirement in the ADR version that a lawyer provide the information that's suggested in the comments. It's merely suggested that he or she do so. And the commission thinks that this limits the effectiveness of that amendment. Commission believes that the proposed version provides more protection to clients. The second issue I'd like to raise for the court is that MRPC 1.8 already contains a similar requirement for independent counsel under section H1, where lawyers are seeking to limit a client's right to sue for malpractice. Those clients must, of course, have independent counsel representing them before they can sign on to such an agreement. And there's been no evidence that this has had a chilling effect on lawyer retention. The commission suggested the argument that this will keep clients from being able to retain lawyers may be overstated. And we encourage the court to adopt the provision as drafted because we believe that this will provide for proper client protection. Thank you.
Thank you very much. Any questions? Next is John Allen.
Chief Justice, Justices, good morning. Thank you very much for the opportunity to appear. I am John Allen, a lawyer with Varnum, LLP, a resident in its Kalamazoo and Naples, Florida offices. Throughout my 50 years of practice, I've had the honor and privilege to serve on the Ethics Committee of the State Bar of Michigan and also Ethics Committees of the American Bar. I've served as an editor of the Ickle book on attorney fee agreements and chair Ickle's annual ethics seminar. I've also been a lawyer advocate for clients and lawyers in arbitrations and also served as an arbitrator in those matters. I also want to disclose to you that Varnum uses arbitration in our services and billing terms, which are available publicly on the firm's website. I'm speaking to oppose the amendment. The underlying premise of the amendment is that arbitration is somehow unfair and works always to the disadvantage of the client in a dispute with the lawyer. That is not my experience. I believe arbitration is fair to all parties. The arbitrator under both the federal and state statute exercises virtually all the same powers as a trial judge. There's a time advantage, I think particularly a consideration after COVID, that arbitration happens quicker. It's usually less expensive. It provides all the same discovery and other vehicles that a court does. Most importantly, it provides confidentiality to the matter to protect the protected information of the client, which often becomes material in these disputes. It's the reason why the state and federal government has such a strong policy in favor of arbitration under the federal statute and under the Michigan Uniform Statute. And that is reflected in the Supreme Court decisions at the federal level and the Watts and Tinsley decisions here in the state. One important element in any conflict analysis, be it 1.7, 1.8, or 1.9, is the client's choice of counsel. And one thing that is not contemplated here is after the client chooses counsel, and that counsel under this amendment were required to tell the client to go get another lawyer to talk about arbitration. If that second lawyer has an arbitration provision, the client then needs to go get a third lawyer in order to talk to the second lawyer about the arbitration. There is also, I think, a lack of empirical evidence. I appreciate the words of my good friend Ken Mogul but that his experience is not mine. If there are vulnerable clients who are being harmed, the arbitrator has the power to consider that. So does the Attorney Grievance Commission. I disagree with the Attorney Grievance Commission's position. I believe arbitration operates well for all concerned. If there's a specific problem with specific lawyers, AGC has the power to deal with that. In fact, AGC recommends arbitration and ADR, particularly in fee disputes. I ask that the court reject the proposed amendment. Thank you.
Thank you, Mr. Brown.
Counsel, I just have a very quick question, and I appreciate your argument, but what I'm trying to grapple with, and I don't want to take too much time, but what's the, I understand the analogy that you just gave, but really the idea here is just making sure that the client is fully informed in terms of the decisions that they're going to make. So isn't this really not about the virtues or values or harms of arbitration, but really just about the idea of making sure that you have an informed client?
Oh, certainly, Justice Bernstein, that is a very reasonable and worthy concept. And I think a well-drafted arbitration provision does exactly that. It tells the client what the advantages and disadvantages are and why the provision is in the fee agreement. I also, frankly, exercise some caution about the term informed consent. I know that it sounds very benign, but when your court considered the Ethics 2000 amendments in your Administrative Order 2003-62, it rejected the idea of informed consent as being too complicated for compliance, something like the ADR section chair just described, and that it would be productive of more litigation and compliance hearings. If you want to take a look at my words on this, I'd refer you to an article I wrote back then. If you just Google informed consent, Michigan Rules of Professional Conduct, the article will come right up. I think consent after consultation is the phrase used in every place except 1.2b of the Rules of Professional Conduct, and that would be the better phrase to use if the court is going to use one at all.
Thank you, counsel.
Thank you, Mr. Allen. That brings us to item number 6, proposed adoption of an administrative order that would increase the state bar's dues for most members by $70 for a total of $385 per year. The first endorsed speaker is Ellen Zwarenstein. Ellen.
Hey, everybody. Thank you, Chief Justice McCormack and the court for a chance to speak today. I am here on behalf of the Michigan Center for Civic Education to support a minimum of an $80 dues increase. In fact, I would support more to do the work that I am here to represent, as well as for a more robust vision of civic and legal health and more points of entry into the legal field. My name is Ellen Zwarenstein, and I have the task of directing this nonprofit throughout the state to eventually serve each and every student, teacher, administrator, and their communities for a more informed, active, and dynamic civic life. The State Bar of Michigan was one of the early founding members of the Michigan Center for Civic Education. Established in 1982, MCCE serves as a vehicle to increase the K-12 participatory opportunities for our communities around civic and law-related education. Knowing that the world is a reflection of what we teach, why we teach, and also how we teach, MCCE helps to champion programs that put students at the center of inquiry and increased appreciation for civic and legal educational communities. Our signature programs include We the People, which are simulated congressional hearings, and a love of constitutional law in particular, mock trial, including having been able to host the first national championship in Michigan ever just earlier this month, and thank you for your involvement with that. Project Community, community conversations, and so much more in terms of teacher professional learning and opportunities for student engagement and student programming. We are grateful to those of you who have supported these activities and can attest to the power of teachers, coaches, schools, districts, and their communities who rally behind meaningful civic and law-related education. Our organization, more than ever, relies on the collaborative spirit to work mutually to enhance both organizations, the State Bar of Michigan and the Michigan Center for Civic Education's shared beliefs and shared visions. We have an opportunity to watch the state bar be extremely efficient in their operations. We see the danger of them being stretched too thin and harming organizations that could otherwise really enhance the field and the reach of more students involved in the law. The last time dues were increased was 2003. At that time, organization like MCCE was largely funded through federal grants and subawards that went away entirely in 2011. Since 2017 in particular, we have leaned heavily upon the public education and outreach committees, the director of outreach and their constituent services to try to meet the needs of the members, to connect them to more schools, as well as to the schools to connect them to the State Bar of Michigan. So there's much more to say, but for right now, we just know that we stand fully behind the dues increase to the State Bar of Michigan.
Thank you very much. Any questions? The next speaker is Amir Abu Aita.
Good morning, Justices. Thank you so much for taking time to let me speak a few minutes about this issue. My name is Attorney Amir Abuela. I am a sole practitioner in Flint, Michigan. I have been practicing law for about 5 years. Next month, it'll actually be my 5-year anniversary of becoming a practicing attorney. And in that time, I've experienced a wide range of issues that bring the question of ethics. And I think I've been told that I'm not alone in facing ethical issues from time to time. Although 6 years ago, I was in law school taking the professional responsibility class and then taking the MPRE directly after that. Practicing law can bring a wide range of issues, with some issues that have been taught and explained at length in this professional responsibility class and during the prep for the MPRE. But some other issues can come up that we were not trained for. And so that at that point, we rely heavily, or we should at least rely heavily on the State Bar Ethics Hotline. I have a lot of great mentors that some are in the law office that I'm currently working in currently, and then some attorney mentors I have from all over the state of Michigan. But sometimes questions go even above their heads, things that they have not experienced in their life or in their career that they can't give me proper guidance for. So with that, I feel the most comfortable having that hotline, especially. Even as a young lawyer like myself, it could be very, very easy for lawyers to spiral out of control with not keeping these ethical issues guided directly. I call the State Bar Hotline currently. I get great responses, and I think we should do whatever it takes to keep that program most efficient and funded the most efficiently. Also, as a young attorney, I know I'm not as established as a lot of the older attorneys that have been in private practice for quite a long time. And I subscribe to a lot of different services that help me in my practice. I think that this is probably the most important service that I actually could subscribe for, and by paying that $80 increase or however much the increase proposition is. And in addition, I totally support the increase because the last time we had to increase, I was actually in 8th grade. And so I think that it's been long overdue of the time that we need an increase. So thank you, Justices, for your time.
Thank you very much. Any questions? Next is Ann Rout.
Good morning, Your Honors. I am the Executive Director of the Michigan Advocacy Program. I'm also speaking today as co-chair of the Legal Services Association of Michigan, or LSAM. LSAM is a nonprofit organization comprised of the 12 largest civil legal aid programs in Michigan. Our programs collectively close about 50,000 cases each year on behalf of low-income individuals and families in the state. LSAM deeply appreciates that the State Bar of Michigan has undertaken an active role in efforts to increase access to justice, and we urge adoption of the $80 increase to support this important work. Just last month, the Legal Services Corporation released the Justice Gap Report, underscoring the stark realities of our justice system. Low-income Americans report that they do not get any or enough legal help for 92% of the problems that have had a substantial impact on their lives. Across the country, legal services programs turn away 1 out of every 2 requests they receive for assistance due to limited resources. While we continue to have a huge unmet need in Michigan, we do better than the national average, largely in part to the partnerships that are committed to increasing access to justice that exist in our state. And those partners include our courts, our local and state governments, the Michigan State Bar Foundation, pro bono attorneys, the legal aid programs, and of course our state bar. The state bar staff support and promote the work of numerous bar committees and work groups that simultaneously impact policy and increase access to justice, while also engaging members of the private bar in work that would otherwise be left to the legal aid community. The bar has done much to support these initiatives among a broad, diverse audience of attorneys in the state, giving those initiatives a greater likelihood of succeeding. Just one quick example is today is the second day of a statewide pro bono training, bringing together the pro bono coordinators of the large firms, solo practitioners, representatives from law schools, and legal services providers. This important training was organized with the assistance of staff at the state bar and has been an annual event now for years. The bar has also been an integral part of the Justice for All Task Force and Commission and the work that the Commission has produced so far. These efforts, in addition to the important regulatory work of the bar, require a great deal of staff time and resources. The bar maintains an ambitious agenda, an ambitious strategic plan, but one that actively advances the notion of justice for all, regardless of personal resources. So on behalf of LSAM and the Michigan Advocacy Program, I urge the court to adopt the $80 increase, ensuring the continuity of this important work. Thank you.
Thank you. Any questions? Jennifer Bentley.
Thank you, Justices, for the opportunity to speak this morning. I'm Jennifer Bentley, the Executive Director of the Michigan State Bar Foundation. The Foundation's board is comprised of 21 leaders from the legal community throughout Michigan, judges, corporate counsels, solo practitioners, and partners in statewide law firms. I'm speaking on behalf of the Bar Foundation Board of Directors, who have voted unanimously in support of the following statement. The Michigan State Bar Foundation partners with the State Bar of Michigan on many access to justice initiatives and supports the request from the State Bar of Michigan's Representative Assembly and Board of Commissioners to increase licensing fees by $80. The Michigan State Bar Foundation offices are located within the State Bar building, so we see firsthand evidence of fiscally responsible decision-making. While the foundation can vouch for the State Bar's frugality and effectiveness, the most important reason I am speaking to you today is because the State Bar of Michigan has played a significant and important role in access to justice efforts. It has led the way at important moments by mobilizing thousands of volunteer hours, not just for traditional responses to the legal needs of the poor through pro bono services, but also for brainstorming and advancing creative solutions for improvements in the justice system, and especially for making legal services more available to all who need them. Some examples include the Judicial Crossroads Task Force that laid the foundation for Michigan legal help and for systemic changes in court operations, including the expansion of treatment courts. Its 21st Practice Task Force advanced the conversations about major regulatory reforms and promoted the advancement of limited scope representation. Currently, the State Bar of Michigan is on the leadership team and an active participant of several commissions created by the court to advance access to justice and other important goals. Michigan is at a critical pivot point for access to justice efforts. The foundation requests that the court approve the State Bar's original request to increase fees. Thank you.
Thank you. Any questions for Ms. Bentley? Thank you. Next is James Liggins.
Good morning, Madam Chair, or rather, Madam Chief Justice and the court, and may it please the court. My name is James Liggins. I'm an attorney at Warner Norcross and Judd here in Kalamazoo, Michigan, and I'm here to speak on behalf of strong support of the full $80 increase to the annual licensing fees that are allocated to the State Bar of Michigan. My primary reasons for support are three. I believe that we should really invest in the meaningful, tangible impact that the State Bar of Michigan consistently does and demonstrates for our legal profession, as well as for the community at large. I am a direct recipient of that tangible, meaningful impact. And let me tell you why. First of all, 2003, I graduated from law school, and I had to go through that infamous character and fitness process that the State Bar of Michigan organizes. Spoke to a panel of attorneys to explain why my horrendous driving record did not disqualify me from practicing law. More importantly, what that process did was it instilled in me a great reverence and respect for this noble profession. And I try to instill that same reverence and respect for our profession throughout the people that I encounter, throughout the people that I mentor myself. So that's exponential impact from the State Bar. Fast forward a few years, and I was invited to participate in the Special Committee on Civil Discovery Court Review, and was able to then focus primarily on trying to update and streamline the civil discovery rules. Fast forward a little bit, few years later, I was asked to be a part of the Judicial Qualifications Committee, and now I'm one of the co-chairs of that committee, working to do a substantial work through the organization, through the State Bar of Michigan, to help with respect to the qualifications of our justices and judges. But even more importantly, you've already heard from Ellen Zornstein from the Michigan Center for Civic Education. And what I found out is that 30 years ago, the State Bar was one of the founding members of the Michigan Center for Civic Education that provides, rather sponsors the high school mock trial program that gave me access to a profession that before that I did not know I had access to. So for me, it is a tangible, meaningful impact that really does, I think, deserve a reward and investment of the full $80 amount. And I would ask that you would approve that. Thank you.
No, so I just have a very good question. I really enjoyed your presentation. Thank you very much. I think you led me to think of just a very, very quick question. And you come from a great firm. Does Warner Norcross, do they pay for your bar dues, or do you pay for that yourself?
That's a really good question. Warner Norcross does pay for our bar dues.
And just, I guess, a follow-up question, and again, these are excellent services, and I really appreciate what you're saying. Do you think you would feel differently if you were a sole practitioner just coming out of school and you didn't have the backing of the law firm?
I appreciate that, Justice Bernstein, and obviously economics always plays an issue with respect to any decisions that you make. But I would suggest to you, Justice Bernstein, that if I had the same types of experiences at the State Bar, through the State Bar's facilitation as a sole practitioner versus as a member of a firm like Warner Norcross and Judd, I would want that same level of support at that $80 increase.
Counsel, thank you very much.
Thank you.
Thank you very much. The next speaker endorsed is Ashley Lowe, and I don't see Ashley in the room. So we will go to Judge Christopher Yates.
Thank you very much, Madam Chief Justice. It's an honor to appear before the court, and I'm delighted to bat cleanup or near cleanup on this issue because I'm following a lot of people I respect who have given you some sense of the scope and reach of the State Bar of Michigan. Although I am currently the president of the Michigan Judges Association, I'm not appearing in a representative capacity. Rather, I'm appearing as one of the greatest consumers of State Bar of Michigan services. I'm on 3 different councils of the State Bar, ADR, Business Law, and Judicial. And I'm a recent consumer of the Judicial Qualifications Committee's work. And in addition to that, as Ellen Zwarenstein and James Liggins explained, The State Bar is so instrumental in the activities of the Michigan Center for Civic Education, which is truly one of the great organizations in the state, and it performs such a valuable service. I've had the great privilege to be the president of several voluntary bar associations, the Grand Rapids Bar Association, the American Inns of Court chapter in Grand Rapids, now the Michigan Judges Association. So I've sat in the room while decisions get made about increasing dues. And every one of these organizations has had to make the decision to increase dues in the last 2 decades. It's odd that the bar has to come to the Supreme Court to ask for an increase in dues, but the fact that the Representative Assembly has voted overwhelmingly to make this request, and the Bar Foundation supports it as well, tells you everything you need to know. Earlier in my career, I was a member of the Representative Assembly, and I can tell you that it is constituted by a membership that includes a wide swath of the State Bar, and I think speaks wisely for the State Bar in making this recommendation for an increase in bar dues. Justice Bernstein asked about the effect on sole practitioners, and I think that's a worthwhile consideration. I just say that although as a judge, my bar dues in Michigan are paid for me, in Illinois, I'm a member of the bar who willingly pays dues every single year, and I've been very pleased by increases by their services because, frankly, I think state bars are so instrumental in making sure that the quality of justice in the state is enhanced. And I can't tell you enough about the value of the State Bar in terms of improving access to justice. I've had the opportunity to serve on several of the rules committees that have proposed overhaul of court rules. It's been extraordinarily well thought out. The State Bar is undoubtedly a responsible steward of its precious resources, and I hope that you will support their request for an increase in dues. Thank you very much.
Thank you, Judge Yates. Any questions? Thank you. Next is Dana Warnes.
Good morning, Your Honors. Thanks so much for the opportunity to be here today. As you know, my name is Dana Warnay. I'm the managing partner of Shaner Cahill and Warnay, which is our family firm in Macomb County. We specialize in probate and estate planning. We are of the solo and small firm type flavor of attorneys that are part of our larger community. I'm here to share with you a bit of an insight into the valuable work being done by the State Bar of Michigan, and I urge you to support the recommendation for the $80 license fee increase. The work of the State Bar is extremely important, and it's too important to undercut the funding of this work. We are not the State Bar. We are not the same bar that we were the last time that we asked for this increase. We have been evolving to respond to the changing needs of our justice system and the legal profession. We've done those things using strong fiscal restraint. We always keep a sharp focus on our governmental status, and we always try to do things the most efficient way possible. We embrace technology, all for the purpose of providing services to Michigan lawyers and the people of Michigan. The mandate of our State Bar is to promote professionalism of lawyers, to advocate for an open, fair, and accessible justice system, and to provide services to attorneys to help them best serve their clients. And to do this, the State Bar does fundamental things, not very sexy or exciting things sometimes, but really essential and fundamental services, things like maintaining our official database of licensed attorneys in Michigan. We also make sure that people who are acting as attorneys are qualified to do so. We carry out investigations of those who are unqualified to provide legal services to make sure to protect the public. And we coordinate our character and fitness admissions under the direction of the Board of Law Examiners, as Mr. Liggins referenced his experience about. Those are the fundamental things we do to service attorneys and to the professionalism of our profession, but we also do things to help lawyers better serve their clients. Our brother counsel, Amir, Abuela, really focused and hit on the Michigan Ethics Helpline. This is one of the major things we do to help make sure attorneys are able to serve their clients in an ethical way. 7 to 9 Michigan attorneys every single day call the Ethics Hotline and ask for help about how to best service their clients. We also maintain the Practice Management Resource Center, This resource helps attorneys improve their practices, making sure they have access to resource and training to maintain tech competency, which is a new part of our professional responsibility. That Practice Management Resource Center has been used more than 4,000 times this year. I'm also very proud and think it's crucial that the State Bar offers wellness programs to offer assistance to attorneys, especially at this time. It's been critical during the pandemic and now moving forward to offer lawyers who are struggling with addiction, depression, and other wellness issues. This service has become more and more essential, and requests for this type of assistance has increased 175% over the last year. As some of the other speakers have already hit on, the State Bar is a leader in access to justice. And so we really want to make sure that we continue that commitment. Our diversity, equity, and inclusion work has also been important. And so in conclusion, I just want to make one final point. We really need to be nimble and to address the needs of our state. We can't do that without proper funding. So I really encourage and request that you support that fee in that amount. Thank you.
Thank you, Ms. Warnay, and I apologize for botching your name. I know better, so I should know better. Any questions? Thank you so much for being here. Next is Joseph Mcgill.
Good morning, and thank you very much for allowing me the opportunity to speak with you today. My name is Joseph Mcgill. I'm a principal at the Foley, Barron, Metzger, and Yite law firm in Livonia. I'm a past chair of the Representative Assembly, and I'm an elected member of the State Bar of Michigan's Board of Commissioners. I currently serve as secretary following my election to the office of treasurer. I've been a member of or chair of the State Bar's Finance Committee since 2018. I'm here to address some of the important aspects of the $80 license fee increase proposed by the Representative Assembly, which embodies the elected leadership of all of the attorneys in the state of Michigan on this particular issue. First, the State Bar of Michigan's annual expenses are $11.2 million. Its current revenue from license fees is $7.6 million. This is by design through its fee cycle budgeting process, which Mr. Cunningham could speak to in greater detail. The State Bar's most recent license fee increase was 18 years ago in 2004. Since that time, through careful financial planning and strict cost controls, the State Bar has been able to stretch and maintain its present fee structure, but is no longer able to do so. As a result, in April of 2021, the Representative Assembly met and a license fee increase of $80 was proposed and approved for your consideration. It's important to note that the duly elected representatives of all the attorneys in the state of Michigan were charged with the responsibility of proposing license fee increases to this honorable court, overwhelmingly supported an increase of $80 after a full and vigorous debate, which I witnessed. The proposed and approved license fee increase of $80 is reasonable and necessary. Here's some of the reasons why. An $80 increase is actually 25% less than a simple increase based on inflation. The $80 increase coupled with a $20 increase for the attorney discipline system lands the State Bar of Michigan within the middle tier of expense for license fees for all state bar associations throughout the nation. Lastly, as time passes, the State Bar's license increase will quickly become more and more affordable as other state bar associations increase their fees through the implementation of their own license fee budgeting cycle. The State Bar of Michigan is an excellent steward of the dollars it receives. It is with this funding that the bar leverages the volunteer services of hundreds of Michigan attorneys, which provides a tremendous intangible value to its members and to the people of the state of Michigan. One example is the Michigan Bar Journal. This is an award-winning monthly publication that has just one full-time employee. That employee coordinates the efforts of a hardworking volunteer committee of 22 attorneys that plan and edit all of the content of the Bar Journal. The tremendous value added that the State Bar generates from the license fee it receives is reflected in the volunteer network of hundreds of Michigan attorneys, which the bar cultivates and maintains. Since the bar does not receive annual funding increases, it has relied upon fiscal discipline to maintain its present fee structure for the past 18 years. It is projected that—
Mr. Mcgill, you're over time. Are you, I don't want to, if you have anything else important to say, please do, but we still have more speakers, so I want to get to all of them.
Here's the important thing, Your Honor, or Justice. Simply put, $50 is not enough. I strongly urge the court to adopt the $80 increase, which was approved by all of the attorneys through their representative assembly. Thank you very much.
Thank you so much. Any questions for Mr. Mcgill? Peter Cunningham.
Thank you, Chief Justice McCormick, and thank you, Justices, for allowing me to speak. I'm Peter Cunningham, the Executive Director of the State Bar of Michigan, and it's been an honor for me to hear the words today of Michigan attorneys whose practices and lives have been, the State Bar of Michigan has been able to impact. I'm certainly able to answer any questions you may have, but out of respect for the court's busy schedule this morning and time, I simply want to state that, or I don't want to repeat what has already been said by our President and Secretary, but I do urge you to support the full $80 increase that we requested. The State Bar of Michigan has been extremely frugal to make our current fee last 18 years, but inflation catches up to all of us. So thank you very much, and I'd be happy to answer any questions.
Thank you. Any questions for Mr. Cunningham?
I don't have a question. I just wanted to make a comment. I want to thank Mr. Cunningham for all of the follow-up and additional information that we've been provided since we first started considering this proposal. So thank you for the work on that.
Thank you, Justice.
Next is Jerome Crawford.
Good morning, Justices. Thank you for the opportunity to speak before you all today. I also want to apologize if there's any background noise and appreciate the accommodation, as I know that I'd be traveling back internationally, so I've done my best to find a quiet space. But in case you're going to do a terminal noise, I am not on a plane, but there may be some nearby. That being said, I thank you for the opportunity to speak today, again, in support of this fee increase. Do not need to echo the comments that have been already said by many of those that spoke before me, and definitely want to say everything's been said has been truly on point. For me, I'm speaking capacity in a couple different concepts. One, in professional capacity, I am the Director of Legal Operations and Social Equity for Pleasantries, and also an adjunct professor at Wayne State Law School, having spent my earliest days in other in-house counsel roles as well as a law firm where I had my state bar dues paid. I appreciate that question from Justice Bernstein about if my dues were not paid, how would I feel, and putting myself in Mr. Ligon's seat. I can certainly echo that sentiment that I would certainly still be in support of this fee increase. Speaking of today is more in my capacity in my service roles, having been an executive council member of the State Bar Michigan Young Lawyers section, which is unique in that all of our members are mandatory. They're forced, if you will, to be members of the Young Lawyers section, so whether you like it or not, whether you check the box. And we've always had to operate with a budget every year that can be very tight. Beyond that, I've done a lot of work with the State Bar, a number of volunteer capacities, notably having been the MC for our annual awards dinners over the years, and look forward to those kind of coming back around. I can personally attest to how frugal the State Bar has operated, and to coin a very popular phrase, very simply put, as noted, the inflation sort of, gets the best of us like Father Time, right? It eventually catches up with you, and yesterday's price is not today's price. So even as well as you operate, no matter what you do, you're going to need to be able to increase. So merely looking at the data that exists and how it's been presented, simply put, the $8 increase, and that is actually still below the inflation, I believe would be $86. To me, it's necessary for us to still do what we do. All these tremendous services and the work of the State Bar has already been articulated better than I could even say. But I want to talk from that capacity, having served in various roles and supported State Bar, know that that fee increase to me is absolutely essential, and definitely urge the court in its adoption of the same. Thank you again for the opportunity to speak this morning, and wish you all well.
Thank you very much, Mr. Crawford. Any questions? Okay, I see Ashley Lowe is now in the room. Ms. Lowe.
Thank you, and I apologize for not being here to my turn earlier. Thank you for the opportunity to speak to this honorable court in support of the fee increase of $80 for the State Bar of Michigan. I'm the Chief Executive Officer at Lakeshore Legal Aid, and Lakeshore is the largest provider of free civil legal services to low-income people in the state. We have 10 offices in the Detroit metro region, including an attorney-staffed hotline that serves the entire state. That means that we currently employ 131 attorneys, And under the proposed fee increase of $80, Lakeshore's cost for bar dues would increase over $10,000 this year. And I speak in favor of this proposal because I believe this money is well spent to support the attorneys and the people of the state of Michigan. Lakeshore staff take full advantage of the services provided by the State Bar. In the complex landscape that we work in and dealing and being the provider of last resort for people when there's no other options for services, our staff reach out to the ethics hotline on a regular basis. I know that they rely on the e-journal and the bar journal for updates on what's happening in the law. And we just recently scheduled a training for self-care and wellness with the director of Lawyers and Judges Assistance Program. In addition to our staff, I've worked really closely with the staff at the State Bar. As the current chair of the Justice Initiatives, I work with bar staff to support pro bono work for low-income people. This work helps provide tenants with representation, helps improve safety and security for survivors of domestic violence, and helps expunge records for people whose actions many decades ago keep them from housing and employment opportunities. I was the former chair of the Domestic Violence Committee, and in that capacity worked closely with bar staff to recruit and train volunteers on trauma-informed practice, ensuring that our volunteers understand the needs of survivors and how to best represent them. And as the current co-chair of a Justice for All Commission work group, I work closely with my bar staff co-chair, leading the assessment and evaluation of triage and referral systems in the state. This work will ultimately lead to improved access to justice for all Michiganders. My experience with state bar staff is only a slice of the work that is done by this hardworking staff. Bar staff have led on so many projects that it's hard to count. They are truly a part of the fabric of the legal profession, and they support our work, our continued learning, and even our lives when things get tough. Their value and the value of the state bar is immeasurable. The bar should be able to hire sufficient staff and pay them appropriately to complete their work, including the work of supporting volunteers to represent the state's most vulnerable citizens. I urge you to support this full increase of bar dues of $80 because I have no doubt that it will be money well spent. Thank you.
Thank you very much. Any questions? Okay, the next speaker is Sean Civic, and I apologize if I did not pronounce your name correctly. You can correct me.
You did not, Madam Chief Justice, and I thank you, if it please the Honorable Court. I'm a member of the State Bar of Michigan Representative Assembly and the current chair of the Lawyers and Justice Assistance Committee. At the risk of needless presentation of cumulative evidence, I am here to speak in support of a fee increase to the full $80 extent recommended by the Representative Assembly. One of the other state bar expenses that bar dues in the state funds is the Lawyers and Judges Assistance Program. And I think it is well known among everybody here that lawyers experience high levels of anxiety, depression, alcoholism, and substance abuse. The mission of the Lawyers and Judges Assistance Program is to support Michigan legal professionals in fostering their general wellness and, where appropriate, to facilitate their involvement in LJAP's monitoring program. LJAP benefits lawyers in distress, the community of lawyers as a whole, law students, bar applicants, and the public. The Lawyers and Judges Assistance Program offers free consultations for legal professionals and their families, clinical assessments, short-term counseling on site for law students, professional training and educational outreach, referrals to properly trained, credentialed, and effective providers, and monitoring. All this is accomplished with a staff of 4 for approximately 40,000 lawyers in the state. That's a demonstration, I think, of the overall careful stewardship of funds that the State Bar of Michigan has demonstrated over the past many years. The $80 fee increase that is being requested and was approved by the Representative Assembly, as has been noted before, is simply an adjustment for inflation over the 19 years since the last fee increase. It is a reasonable request. It is a needed request. It is a request that will ensure the long-term health of the State Bar of Michigan. And I recommend a fee increase to the full extent recommended by the Representative Assembly. And I thank the court.
Thank you very much. Any questions? All right, the next speaker is Kimberly Jones.
Thank you. I'm sorry, I was trying to get my thing unmuted. Good morning, Chief Justice McCormick. Thank you for allowing me to address the court this morning. Thank you, Justice, so much for your service to the community by serving on the court. I'm speaking as a member of the State Bar of Michigan, and I'm in support of the $80 increase in dues. Kurt Vonnegut said, in this world, you get what you pay for. However, in this particular case, we have not. In fact, we've received much more than we have given. The SBM has had the same due structure since 2004, while the rate of inflation has skyrocketed, especially in light of the COVID pandemic. Operating under a due structure nearly 20 years old is a testament to the State Bar's great stewardship of member money. I've been a member of the bar since 2016. I'm a late in life lawyer, and I have reaped the benefit of the State Bar's good work. In spite of being a part-time lawyer, working as a community college instructor to pay the bills while helping low-income and indigent clients access legal help, I happily have paid my own dues, Justice Bernstein. Being a member of the Michigan Education Association for 19 years, along with serving as a representative assembly person for my local WCCEA for 5 years, I know how difficult it is to decide to bring a dues increase to the table. There are typically fancy money people who can do all types of math wizardry to project the future financial viability of the organization. I do not profess to know the inner workings of such calculations. As my Cass Technical High School AP Calculus teacher can attest, math makes me angry and is an elusive majesty to me, which is why I became an English teacher and a lawyer. However, because they have done the math, I trust the SBM's request for the $80 increase. I would request that the court allow the SBM to have the full $80 requested. Otherwise, I fear services they currently provide would be adversely affected. Justice Sonia Sotomayor discusses her upbringing in a way that I think is relevant today. I listened very, very carefully to the world around me to pick up the signals of when trouble was coming. Not that I could stop it, but it made me observant. In times such as these, reading signals is an imperative. My recent post as Director of Innovative Inclusion for the Washtenaw County Sheriff's Office has positioned me to see the impact of economic instability on communities. We live in a time when racially motivated terrorism runs rampant, gun violence is at an all-time high in high poverty neighborhoods. And these are the times in which we lawyers live. Because these are the times, the ripple effects in our communities lead to ripple effects in justice systems, whether civil or criminal. This makes the job of lawyering much more intense if that could be possible. The SBM offers many services to us, which have been generated here, so I won't go back to it. But I will say, in my work with the Michigan Center for Civic Education, the State Bar has been imperative in their assistance. So I'm just simply asking you to give the full $80. I wholeheartedly support it. Thank you.
Thank you so much for your comments. Any questions? All right, thank you all. The next item is number 7, a proposed amendment to Michigan Court Rule 8.110 that would require courts to observe Juneteenth as a holiday. We have one endorsed speaker, Zanelle Brown. Good morning, Zanelle.
Good morning. Thank you, Justice McCormick, Chief Justice McCormick, and thank you to the esteemed bench. I am speaking on this issue not as a court administrator, but I'm speaking on behalf as the co-chair of the Women Lawyers Association of Michigan Diversity and Inclusion Committee. And I also want to bring my perspective as being a practicing attorney in the legal community for the past 25 years, active in various bar associations in our legal community. First off, I want to mention today, on this day in 1896, our U.S. Supreme Court decided Plessy versus Ferguson, which made separate but equal the doctrine of our country. And as we can see, we continue to have the conversation, where does race relation really fit into our society, and how do we achieve the equality that we've promised? The Women Lawyers Association of Michigan supports the recognition of Juneteenth as a court holiday. We support it statewide. This day is historic not just for the African American communities we serve, but it symbolizes to all the communities, and it helps bridge the gaps of many of the disenfranchised and marginalized communities across our great state. This embodies inclusion. However, we also recognize that if we just put it out there as a holiday, but not supplement it with education and additional awareness, whatever we do is just going to be performative. So we ask that the Supreme Court look at that. And I know your immediate issue is how should it be observed? Is a moment of silence adequate? Should it be a court closure holiday? For this, I'll provide some personal perspectives. As an administrator, I deal with a lot of logistics such as backlogs, such as funding issues. When are our funders closed? When are our partners closed? In Wayne County, this became a holiday that was recognized by the CEO of Wayne County last year. Our court had not recognized it. So our funding unit encountered having to pay overtime to make sure that we had the staff needed for our courts. It was also recognized by 36th District with a court closure. I can't speak to what logistic issues they had. This year, we did submit it in our LAO to have it recognized as a court closure holiday. So we're now in line with our funding unit. I realize that in other jurisdictions, they're going to have to look at these issues too. So unfortunately, I don't have a one-size-fits-all type of suggestion for the Supreme Court to take. The only thing that I can suggest at this point in time is that we need to have additional conversations. We also need to look at the importance of other holidays and make sure that we're educating and making others aware of that. So sorry, I don't have a final answer or suggestion for you, but I do think the conversation is a worthy one. I do support that it is a holiday that is recognized statewide by the courts. I just can't tell you how best to do it. And that concludes my remarks.
Thank you very much. Any questions? Thank you for being here. The last item is item number 9, an amendment of Michigan Court Rule 7.306 that creates a procedure specific to original actions relating to cases filed involving the Independent Citizens Redistricting Commission. We have one endorsed speaker, James Gallant. Mr. Gallant, I see you in the room, but you are muted and your camera's not on. Mr. Gallant may be otherwise occupied. Oh, there you go.
Oh, there you go. Okay. Thank you very much. My name is James Gallant. I'm with the Marquette County Suicide Prevention Coalition, and these are my opinions. And I endorse these rules, and I would ask you to please consider expanding this rule to include the Board of State Canvassers. There was a tight situation the last time in the elections when it was thought that stuff was going to have to go through court, and it would be a straight line to the Supreme Court would probably be helpful. And I think one of the biggest and most relevant controversies in our state is what exactly are the legitimate rules of procedure at these types of public bodies and boards and committees. And like the one speaker was talking about, the wellness and law task force that's being, I've reached out to people and asking about the rules of procedure. Apparently they don't have that worked out yet of how that's going to work. And that's important. And how are the advice that you're getting today from the state bar, how does that work? And how are those rules working up the pike to get to you? And I think that the biggest problem we have is it's like the born-on date. You know, it's been stated in proceedings by plaintiffs and defendants that this commission was born in 2018 by amendment to the Constitution, when the Supreme Court has determined that no, it was born in 1963. And there's rules of procedure from the 60s and 70s and 80s that were not brought forward, and they were not used. They were not followed, and including the Robert's Rules of Order. Because on page 366, line 8, it says that you shall have no debate before there's a motion that's properly seconded. And I would encourage everybody to go back to the last few meetings of this redistricting commission and watch them. And they don't do that. The chair assigns the floor to the vice chair to facilitate the next discussion of the next items. And then they negotiate the motion before it's even formally brought before the commission. Everybody has a right to know what they're going to vote on next. And I'm hoping that the Constitution protects my due process, the rules of procedure that have been implemented there. And it's negotiated, it's straw polling the whole time. So I'd ask you please to go back and to look at those. And lastly, I'd like to say that in my research, it shows that there are three things that are useful that a person who may be in a suicidal crisis. And one is to tell them very clearly that there's no future in suicide. And that causes them to think about that part of the equation, that there's no future for them and there's no future for any of the issues or anything, that doesn't resolve anything. And that's a good icebreaker. You'd say it to somebody, say there's no future in suicide, and it may opens up the subject to them. And then you remind them of the important things that make life worth it to them, family, religion, and things like that would make them reconsider. And that, we're going to work on this tomorrow. We're going to work on it more, and that and there's things that can be done. And it's the dawn of the day that you just want to work in again tomorrow. And these are the things that are helpful. There's three concrete things that are helpful for a person that may be in crisis for suicidal behavior. And but I think this is creating an increased risk of suicidal behavior in our community. We come to these boards and meetings and committees, and we just don't stand a chance. They don't even know what the rules are. The people on the boards and committees don't know what the rules are. Secretary of State Benson didn't even provide the book, the rule book to the members.
Mr. Gallant, your 3 minutes. Yeah. Your 3 minutes have concluded. Thank you very much for your comments, and thank you for your work.
Do you have any? Well, thank you. And do you have any more questions?
I'll see if anyone has any questions.
Okay, thank you.
I don't see any, but thank you very much for your excellent work. Thank you for being here. That concludes today's public hearing. We are grateful.
We'll come back to speak to you about this stuff again, maybe.
Okay, sounds great. We look forward to that.
In front of the court. Thank you.
Okay, thank you so much. Okay, that concludes the hearing.